Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Podcasting at a conference, the most hectic of all endeavors, particularly as I'll be on vacay next week. Enjoy Liz and Eddie, who will be graciously filling in. As I sit here at 10:30 p.m. in my room on Thursday night in the alligator-infested Gaylord Hotel, the Supreme Court has not yet issued its potentially devastating decision in the prosecutorial discretion case. If it does, I fear I may have to kick it to Liz and Eddie next week. Time will tell. Starting off with the Supreme Court nonetheless. By the way, AILA National, awesome conference so far. My immigration attorney colleagues are a weird, nerdy, passionate, and very fun bunch. Hats off to you all, weirdos. Our first case is United States v. Texas, published by the U.S. Supreme Court on June 23, 2023. So that whole I'm not going to do the PD case if it comes out on Friday thing didn't work out so well. Midway through my interview with AILA's immediate past and current presidents, bam, United States v. Texas. The AILA presidents and I cheered and celebrated together and then got back to our interview. Screw it, I'll do it. Special episode interview coming out in the next few weeks, by the way. Another case titled U.S. v. Texas. Seems like the Supreme Court has one of these in different contexts pretty much every year when there is a Democrat in the presidency, no? And oh boy, as you may have heard, the Supreme Court saved immigration and the novel proposition that humans should be treated humanely. The holding is wonky, legal, and boring. The states of Texas and Louisiana, and seemingly any state, lack Article 3 standing to challenge DHS Secretary Mayorkas's memorandum titled, quote, Guidelines for the Enforcement of Civil Immigration Law, end quote. Colloquially known as the PD memo or Mayorkas memo. With no proper lawsuit to challenge that memo, it remains in force, or perhaps is now back in force, unchallenged. That's how wonky legal procedure has big substantive results. I can hear Civ Pro professors everywhere cheering. Justice Kavanaugh issued the majority decision, joined by the Chief, and Justices Sotomayor, Jackson, and Kagan, while Justice Gorsuch concurred in judgment in a concurrence joined by Justices Barrett and Thomas. That's 8 justices. Justice Barrett also issued her own concurrence joined by Justice Gorsuch. Justice Alito dissented. The Mayorkas guidelines at issue, quote, prioritize the arrest and removal from the United States of non-citizens who are suspected terrorists or dangerous criminals, or who have unlawfully entered the country only recently. For example, Texas and Louisiana sued the Department of Homeland Security. According to those states, the department's new guidelines violate federal statutes that purportedly require DHS, to arrest more criminal non-citizens pending their removal, end quote. Emphasis by the court. Arrest and detain them all, the states desire. Quote, but this court has long held that a citizen lacks standing to contest the policies of the prosecuting authority when he himself is neither prosecuted nor threatened with prosecution, end quote. The Supreme Court now held that that same standing rule applies to the states. No dice, Texas. Although arguably run by crazy people, it's not like the states of Texas and Louisiana had a crazy substantive argument, at least statutorily speaking. The immigration detention statute at issue uses the word shall detain. There's circuits and Supreme Court precedent that says shall means must, as in you need to do it. No exceptions. And Justice Alito's past opinions and logic in other cases gave the states a guaranteed vote, which they got, by the way. I don't want to get into the substance anymore because that's not what this decision is about, and I don't want to stray outside my lane. But a judge in the Southern District of Texas bought the argument and also found that Texas and Louisiana would incur costs if the U.S. didn't detain thousands of individuals at like $200 per day that it didn't want to detain, such that the states had standing to sue. Then the district court vacated the Mayorkas guidelines. The Fifth Circuit declined to stay the lower court's decision. The Supreme Court has now vacated all of the actions of the courts below. The states don't even have standing to sue in cases like this. Standing, as we know, is Law School 101. And, quote, by ensuring that a plaintiff has standing to sue, federal courts prevent the judicial process from being used to usurp the powers of the political branches, end quote. That is, Article 1 Congress and Article 2 Executive. The judiciary is not a political branch. Louisiana and Texas came to the Supreme Court with nothing to support their novel standing argument. As Justice Kavanaugh explains, quote, the states have not cited any precedent, history, or tradition of courts ordering the executive branch to change its arrest or prosecution policies so that the executive branch makes more arrests or initiates more prosecutions. On the contrary, this court has previously ruled that a plaintiff lacks standing to bring such a suit, end quote. Simply put, you can't sue to force a prosecutor to prosecute more people or a cop to arrest more people. So too with immigration enforcement, said the Supreme Court. Historical analysis is all the rage these days before the courts. Quote, a telling indication of the severe constitutional problem with the state's assertion of standing to bring the lawsuit is the lack of historical precedent supporting it, end quote. In legalese, this dispute brought by the states is not redressable by a federal court, injury or no injury. Why not? Well, the Supreme Court explained many reasons, including the fact that, quote, lawsuits alleging that the executive has made an insufficient number of arrests or brought an insufficient number of prosecutions run up against the executive's Article 2 authority to enforce federal law, end quote. I seem to recall a pending DACA challenge where such a quote might be relevant. DACA is, after all, at base a discretionary executive decision to not seek the removal of certain non-citizens. And quote, under Article 2, the executive branch possesses authority to decide how to prioritize and how aggressively to pursue legal challenges against individuals who violate the law, end quote. Want more? Me too. Quote, that principle of enforcement discretion over arrests and prosecutions extends to the immigration context, end quote. I seem to recall a pending DACA challenge where such a quote might be, okay, you get the point. Heads up though, there's some dicta later in this decision that waters down what at first blush does seem like a strong case supporting the U.S. government's position in that pending DACA challenge. Looking forward to talking about that case in the next year or two after a federal district judge in Texas and then the Fifth Circuit rules. Anyway, so there's an Article 2 problem that bars standing in this case. Action by the Article 3 judiciary would infringe on the Article 2 executive's prosecutorial authority. Not only that, but quote, courts generally lack meaningful standards for assessing the propriety of enforcement choices in the area, end quote. Article 3 courts are there to just decide balls and strikes, as the chief said during his confirmation hearing. The executive branch has limited funds and the authority to prioritize its enforcement efforts, and it's not for the states or the judiciary to second-guess that. In this vein, all 5 presidential administrations, quote, have determined that resource constraints necessitated prioritization in making immigration arrests, end quote, since the passage of the draconian mandatory detention provisions in 1996. At base, quote, if the court green-lighted this lawsuit, we would anticipate complaints in future years about alleged executive branch under-enforcement of any similarly worded laws, whether they may be drug laws, gun laws, obstruction of justice laws, or the like. We decline to start the federal judiciary down that uncharted path, end quote. There are limited circumstances where prosecutorial decisions can be challenged. This ain't one of them. Some selective prosecution dicta here that I'd use, though, if I was Donald Trump's lawyer. Just saying. I'm sure they know about the case. If anything, this is a matter for Congress to get involved in, not the court and not the states. So, the majority staves off chaos and truly mass civil incarceration of non-citizens. Calling the matter a, quote, extraordinarily unusual lawsuit, end quote, and not in a good way, the court found the states can't even bring it. PD lives on. Long live PD. The concurrences got to the same result in slightly different ways. Justice Alito would find standing, stating that he fears, at the given moment, that the majority's decision and logic constitutes too expansive a grant of authority to the U.S. President. Prosecutorial discretion lives. Immigration prosecutors have authority to consider the interests of justice in their prosecutorial immigration decisions. A good day for immigration and humanity. And that is United States v. Texas. Sticking then with the Supreme Court, we have Pugin v. Garland, published by the Supreme Court on June 22, 2023. Justice Kavanaugh delivered the opinion for a 6-justice majority, with Justice Jackson joining the majority and also filing a concurring opinion. Justices Sotomayor, Gorsuch, and Kagan dissented. And while I am saddened by the result, I must thank the court for its gracious 10-page majority opinion, surely recognizing my competing AILA conference obligations. The Supreme Court has affirmed the Fourth Circuit's precedential decision in Pugin v. Garland, Episode 84, and vacated the Ninth Circuit's contrary decision in Cordero-Garcia v. Garland, Episode 121, which actually is also directly before the Supreme Court here. In so holding, the Supreme Court has also essentially agreed with the BIA's decision in matter of Valenzuela-Gallardo and the First Circuit's decision in Silva v. Garland, Episode 97. Got it? While the ruling is simple enough, the issue is complicated, as it regards the aggravated felony definition at INA Section 11843S, an offense relating to obstruction of justice. I discussed the underlying facts when I did the Pugin and Cordero-Garcia decisions, but I'll talk a bit about them here, and really the legal issue is the same. Will a state offense that criminalizes obstruction of justice, quote, even if the offense does not require that an investigation or proceeding be pending, end quote, match the federal aggravated felony definition of obstruction of justice? Does the federal definition of obstruction of justice require that a defendant obstruct actual pending criminal investigations or proceedings, or is it sufficient that the action obstruct related activities, quote, such as threatening a witness to prevent the witness from reporting a crime to the police, end quote, in the first place? That's what one of the respondents did here. Mr. Cordero-Garcia dissuaded a witness from testifying against him pre-investigation, and was convicted in California of doing so. Mr. Pugin similarly was convicted of, quote, being an accessory after the fact to a felony, end quote. At the time he was accessorizing, there wasn't a criminal investigation yet. Police didn't even know a crime had been committed. So what's the answer? Does it have to be an ongoing investigation obstructed to qualify as federal obstruction of justice? It does not. INA Section 101A43S covers more conduct than the Ninth Circuit said it did. It covers pre-investigation obstruction. What is obstruction of justice? That is the question before the Supreme Court. And as is its wont, the Supreme Court first turned to esteemed dictionaries from the year of INA Section 101A43S's passage in 1996. For example, reasoned the court. At the time, Merriam-Webster's defined the term to include, quote, influencing, threatening, harming, or impeding a witness, potential witness, juror, or judicial or legal officer, or by furnishing false information in or otherwise impeding an investigation or legal process, end quote. Seems to be what Mr. Cordero Garcia did. And, quote, notably missing from those dictionary definitions is a requirement that an investigation or proceeding be pending, end quote. Does the nefarious dictionary cabal know how insanely influential its work has become? I wonder. Federal law has similarly, quote, long prescribed various obstruction offenses that do not require a pending investigation or proceeding, end quote. The Supreme Court mentioned some federal criminal statutes that are obstruction adjacent and don't require pending or ongoing proceedings. Not only that, agreeing with the U.S. Solicitor General, but many states in 1996 criminalized obstruction offenses even if there wasn't an active investigation going on yet at the time of the obstruction. Plus, that Congress defined the aggravated felony by using the word relating to, rather than just outright direct obstruction of justice, further shows that, quote, Congress accounted for the variations, end quote. The Supreme Court gives an example, quote, a murderer may threaten to kill a witness if the witness reports information to the police. Such an act is no less obstructive merely because the government has yet to catch on and begin an investigation. As the Solicitor General persuasively states, one can obstruct the wheels of justice even before the wheels have begun to move. Indeed, obstruction of justice is often most effective when it prevents an investigation or proceeding from commencing in the first place, end quote. To hold otherwise, reasoned the court would exclude lots of state crimes from the federal aggravated felony definition. Indeed it would. The court wasn't willing to do it. Messrs. Pugin and Cordero Garcia, of course, had arguments to the contrary, which the court rejected in 2 pages. The fact that some federal statutes might actually require that the obstruction relate to an ongoing proceeding isn't overly relevant to the court because the aggravated felony definition, unlike others, doesn't cross-reference specific federal criminal statutes. Instead, it talks broadly about offenses that, again, relate to obstruction of justice. The Supreme Court also chose not to apply the rule of lenity because it believed other sources clear on the issue. Which means that the non-citizens lost, and INA Section 101A43S covers more conduct than some of us would like it to. And that the law in the Ninth Circuit has just changed. A not-so-favorable crimmigration decision. But at least I can stop summarizing 101A43S decisions. They are very complicated. My thoughts and the concurrence and dissent. First, what you're dying to know. What isn't included in the Supreme Court's definition of aggravated felony obstruction of justice? Well, in a footnote, the Supreme Court seems to agree with the Solicitor General that only crimes that require, quote, an intent to interfere with the legal process, end quote, qualify. So there's your mens rea. Also, the Supreme Court agrees with the Solicitor General that, quote, federal misprision of a felony is not an offense relating to obstruction of justice because the crime does not require an intent to interfere with the legal process, end quote. Also not a CIMT in most circuits, by the way. Justice Jackson, in her concurrence, wrote to explain an alternative possible reason for why there is no pending investigation requirement to the obstruction of justice definition. She does, however, and seemingly for no reason, note the, quote, drastic deportation sanction, end quote, at issue here. Quoting Jordan v. DeGeorge of all cases, the 70-year-old seminal and only Supreme Court CIMT case. Might Justice Jackson be telling us that she's down to rethink DeGeorge under the modern moral turpitude standards, given the drastic consequences that decision envisions? Stretching the tea leaves there, but who knows? Justice Sotomayor, Gorsuch, and Kagan believe the majority is wrong pretty much in every way. It believes the majority turned the, quote, categorical approach on its head, end quote. The dissent reasoned that, quote, instead of focusing on whether a pending investigation or proceeding is part of the heartland of obstruction of justice, the majority wanders off into an array of obstruction-adjacent federal and state laws that do not require a pending investigation or proceeding, end quote. Looks like the dissent is saying that whatever relating to means, you have to first appropriately apply the categorical approach to the heartland definition of the removable offense. Well said, if my paraphrase is correct. And that is Pugin v. Garland. Next is Figueroa Ochoa v. Garland, published by the Ninth Circuit on June 20th, 2023. Big, bad decision on jurisdiction. The Ninth Circuit has ruled, to use Sabrina Damas' phrase, that after Patel, it lacks jurisdiction to review an IJ and the BIA's denial of a continuance and motion to remand, where the purpose of either relates to an application for cancellation of removal. That is a big holding, and it is certainly not what Patel directly held. Let's step back. Mr. Figueroa Ochoa is from Mexico and, once found removable, applied for non-LPR cancellation of removal under INA Section 240A-B. But the immigration judge believed that he had criminal convictions that made him ineligible for relief, 3 minor drug offenses from the late 1990s and 2000. At his hearing, however, Mr. Figueroa Ochoa countered that actually the first incident wasn't a conviction, and that the second incident was a mistake in his criminal history report, and that actually it was his brother, not him. As to the third conviction from 2000, well, Mr. Figueroa Ochoa was in the process of getting it vacated for, it appears, constitutional or procedural defects in the underlying conviction. So he wanted a continuance to let that play out. The IJ denied, however. And I guess the IJ read the criminal history a bit differently? Unclear. The IJ ordered Mr. Figueroa Ochoa removed. But then, quote, despite the immigration judge's skepticism, the state court did vacate Mr. Figueroa Ochoa's 2000 conviction, end quote. By this time, the matter was on appeal to the BIA, mainly on the denial of the continuance. And so, with that 2000 conviction vacated, Mr. Figueroa Ochoa filed a motion to remand back to the IJ. The BIA denied, messing everything up. The BIA never mentioned the 2000 conviction in its decision, and twice discussed how Mr. Figueroa Ochoa was trying to get his 1996 conviction vacated, which of course is not what was happening, and is not what did happen. Oil argued no harm, no foul before the Ninth Circuit, and the Ninth agreed. It believed that the BIA was really talking about the 2000 conviction, even though it clearly messed everything up. In any event, the BIA didn't think a remand necessary because it believed it wouldn't change anything, because Mr. Figueroa Ochoa still had that second 1999 conviction. The one he said was really his brother. Weird case. Motion to remand denied, and the denial of a continuance affirmed by the BIA. And that's primarily Mr. Figueroa Ochoa's argument before the Ninth, that the BIA erred in attributing that 1999 conviction to him. And if it's not him, he'd clearly be statutorily eligible for non-LPR cancellation, so a remand to the IJ might very well be in order. Maybe I'm sympathetic, but that's a strange argument to make unless it's true. I can only imagine that Mr. Figueroa Ochoa submitted and had evidence showing that 1999 conviction pertained to his brother, and not him. No matter, said the Ninth Circuit. INA Section 242A2BI divests circuits of jurisdiction over review of judgments of certain forms of discretionary relief, including non-LPR cancellation of removal. The 11th Circuit and then the Supreme Court took a very expansive view of that statute in Patel and held that it therefore divests circuits of jurisdiction over, quote, any and all decisions relating to the granting or denying of discretionary relief, which plainly includes factual findings, end quote. Big problem, said the Ninth Circuit panel here, because it saw a straightforward factual question before it. Who was convicted in 1999? The brother or Mr. Figueroa Ochoa? The answer to that question in turn impacted the BIA's granting, or in this case denying, non-LPR cancellation of removal, or a remand for Mr. Figueroa Ochoa to apply for it. Therefore, reasoned the Ninth Circuit, this factual dispute was integral to the BIA's judgment to affirm denial of a continuance, deny the motion to remand, and therefore uphold the judgment denying non-LPR cancellation of removal. Couple steps there to lack jurisdiction. To the Ninth Circuit, that meant Patel governs, and the Ninth Circuit could not review the BIA's factual decision on the issue of whodunit in 1999, even if it disagreed with the BIA. Which, quite frankly, it doesn't appear to, but that's not really the point. Agreeing with the Fifth Circuit in Perez v. Garland, episode 158, the Ninth Circuit held that it, quote, lacks jurisdiction to review the BIA's decision not to remand to the IJ to consider new evidence supporting an application for discretionary relief, end quote. Circuit split with at least the Eighth and First Circuits from episode 134 and 129. As if Patel resolved anything. And that is Figueroa Ochoa v. Garland. Moving on, Giron-Molina v. Garland, published by the Second Circuit on June 20th, 2023. This case is about crimes involving moral turpitude, and I've been talking about it to everybody at the conference who will listen to me. Just a heads up, the facts of this case are gruesome, so just be prepared. Ms. Giron-Molina is from Mexico, and it would appear that she's a lawful permanent resident. The decision leaves all of this out, but it would appear that DHS alleged in removal proceedings that she had been convicted of a crime involving moral turpitude committed within 5 years of receiving LPR status. Again, it's really unclear, because the only thing that matters in this decision is whether this Arkansas conviction that I'm about to talk about is a CIMT. Ms. Giron-Molina's conviction is just terrible all around. Abuse of a corpse, in violation of Arkansas Code Annotated Section 5-60-101, which Ms. Giron-Molina received after, quote, concealing her child's body in a closet after he was murdered by Tyler Hobbs, end quote. Incredibly, after stating that sentence, the decision does not mention anything more about the incident or who Tyler Hobbs is. But I assume that he had some relation to Ms. Giron-Molina. A Google search shows that her child was 1 year old. Terrible stuff. But Ms. Giron-Molina didn't kill her child. And there's no indication from this decision, at least, that this wasn't the worst and most devastating thing to ever befall her. The question is legal. Is the abuse of a corpse generally, in violation of the Arkansas statute, always a CIMT? It is not, said the Second Circuit. Generally, quote, to involve moral turpitude, a crime requires two essential elements, reprehensible conduct and a culpable mental state, end quote. Here, the Second Circuit held at a minimum that Arkansas Code Annotated Section 5-60-101 doesn't necessarily require reprehensible conduct. The Second Circuit held that Arkansas statute was divisible into two separate offenses. Subsection A1 essentially criminalizes mutilating a corpse, while subsection A2 criminalizes the mistreatment or concealment of a corpse, quote, in a manner offensive to a person of reasonable sensibilities, end quote. However, the Second Circuit couldn't figure out which subsection Ms. Giron-Molina was convicted of, because the indictment charged her as simply having committed the statute as a whole generally, and lists allegations that are relevant to both subsections. Shouldn't that actually then indicate that the statute is not divisible? Unaddressed here. To the court, though, that meant that even though it believed the Arkansas statute divisible, it didn't know what Ms. Giron-Molina did. So the court held that her conviction is only a CIMT if the entire Arkansas statute, in all circumstances, both subsections, matched the definition of a CIMT. Again, the Second Circuit said it did not. And surprising to me, it's actually subsection A1 that makes the statute overbroad and not reprehensible. Because in addition to mutilating a corpse, subsection A1 also criminalizes the removing or disinterring a corpse. Not necessarily reprehensible. Quote, for example, a family violates the statute if it disinters a loved one's body from a cemetery and reburies it in a family plot without completing the paperwork required by state law, end quote. Nor is it, quote, uncommon for floods and hurricanes to rip bodies from their graves or crypts. If someone went to an Arkansas cemetery as floodwaters rose and removed a coffin containing the body of a family member so that it would not be damaged or washed away, their actions would violate the statute, end quote. Not reprehensible. How'd the BIA miss this? Well, it mistakenly applied the realistic probability test in a way not applied in any circuit except the Fifth Circuit, and held that Ms. Giron-Molina needed to first find a case where the Arkansas statute was applied in one of those overbroad manners. Not so, said the Second Circuit, as the Second Circuit appears to be reading the Arkansas, quote, statutory language itself, end quote, as overbroad. The text of the statute is overbroad. Realistic probability has no role to play. In a quote I simply love, the Second Circuit explains that the realistic probability test, quote, applies only when there is a match between the state statute and a federal standard, but a petitioner posits imaginative scenarios in which the state statute would be violated in such a way that does not meet the requirements of a CIMT, end quote. The realistic probability test is a shield for non-citizens, nothing more. Not the case here. This Arkansas statute is not a CIMT. Congratulations to Lar Nokomovich for petitioner. And I don't want to pour cold water on this decision, but just be careful. As I mentioned, it appears that all of this is taking place in the removability context, where DHS had the CIMT removability burden. But the decision is less than clear and also mentions cancellation of removal. If instead what's happening is that Ms. Giron-Molina is removable under, say, Section 212 A6AI because she entered the U.S. without inspection, and the CIMT discussion is occurring in the relief context, the Second Circuit's decision might be a bit shaky. If that is the scenario, then the fact that the Second Circuit summarily deemed the statute divisible without much analysis, and then held that the record was ambiguous as to the subsection of Ms. Giron-Molina's conviction, would seem to actually cut against Ms. Giron-Molina due to the Supreme Court's Pareda decision, and it might mean that she should lose. Assuming, of course, as the Second Circuit kind of implies but never actually says, that subsection A2 is sufficiently reprehensible. Anyway, I'm sure Pareda doesn't apply here, because although the decision is less than clear, I'm sure this is all happening in the removability context. And that is Giron-Molina v. Garland. This podcast is sponsored by Journey Business Plans. Journey is the leading business immigration plan writing company in the United States. 10 years. And they know immigration. Heck, they started as an E2 company themselves. Journey prides itself on its responsiveness and overall customer service, preparing business plans for E2, EB2 NIW, L1, EB5, and much more. If you don't yet know about Journey, and don't want to listen to just me, ask your colleagues. Or even better, try them out. Visit www.journey.com and use promo code REVJOURNEY30 for a 30% discount on your first business plan. That's REVJOORNEY30. Or click on the link in the show notes. This podcast is also sponsored by Capital Good Fund. Millions of families seeking to improve their immigration status face financial barriers due to the high cost of legal services. Nonprofit Capital Good Fund is working to make these resources available to all, especially those who would otherwise not qualify for traditional loans. Certified CDFI Capital Good Fund is partnering with attorneys to provide the financial services families need. They offer affordable financing with no closing fee or down payments for those working with attorneys to move their case forward and get attorneys out of the accounts receivable business. To learn more about the program, email immigration@goodfund.us or call 866-584-3651 and tell them who sent you. Moving on to AG v. Garland, published by the Fourth Circuit on June 23, 2023. The Supreme Court wasn't the only court to get in on my exceptionally busy Friday at the conference. but I can't be mad at the Supreme Court, and I can't be mad at the Fourth Circuit either. This decision is about asylum and nexus. Mr. AG is from El Salvador, from an area, quote, dominated by MS-13, end quote, that horrifying international criminal gang that controls much of El Salvador, Honduras, and other countries. In the early 2000s, saying they knew that Mr. AG had family in the United States, MS-13 members said that he either needed to join or pay them money to fund the gang. If he didn't, they would, quote, cut his tongue out and kill him, end quote. They made similar demands and threats to Mr. AG's brother, Victor. Victor refused and fled within El Salvador, internal relocation. MS-13 found him and murdered him. The family never contacted police, but police on their own filed a report, but they never investigated the murder. A few years later, MS-13 approached Mr. AG, made the demands again, and threatened to decapitate him the next day if he didn't comply. They came at him and attacked him with a knife during the incident itself, requiring emergency room treatment. Mr. AG fled to the U.S. shortly after his release from the hospital. He didn't think that the police in El Salvador could protect him, and he didn't report it. MS-13 continued to make demands of and threatened Mr. AG's remaining brothers in El Salvador, saying that they would, quote, kill all young male members in the petitioner's family, end quote. A nice quote for Nexus. So all of the remaining brothers fled except one, Moises. When Moises refused to smuggle drugs into prison for MS-13 and fled the area, the gang found him and threatened to murder him too. So he fled to the United States. With all of the brothers gone, MS-13 spray-painted their house with gang materials to, quote, mark their territory, end quote. Kind of like a dog would, if he could paint. Mr. AG entered the U.S. without authority, and when he came to the attention of DHS a few years later, filed for asylum and related relief in immigration court. Past the 1 year, though. Let's see what happens there. Mr. AG was adamant that he'd be killed by MS-13 if returned to El Salvador. But the immigration judge saw it all as simple extortion, gang recruitment, and murder, of course, rather than something on account of a protected ground. To the IJ, quote, family membership was simply incidental to the claims for a nexus, end quote. The IJ denied Convention Against Torture Protection too, essentially because Mr. AG and his family never sought police assistance. The BIA affirmed the IJ. Mr. AG moved for reconsideration, perhaps anticipating a different outcome in the Supreme Court's Santos Zachariah decision a few weeks ago? I don't know. But unnecessary to bring the challenge to the circuit now. The BIA denied reconsideration, and so it would appear past the 30-day deadline to petition for review the denial in chief from the BIA. Mr. AG challenged the denial of reconsideration in this decision before the Fourth Circuit. But the Fourth Circuit kind of treated it all like a straight challenge to the asylum denial. Mr. AG asserted that he suffered and feared persecution in El Salvador on account of his membership in his family, which the Fourth Circuit has held, quote, provides a prototypical example of a particular social group, end quote. You'll be seeing that on Instagram in the coming weeks, I promise. So Mr. AG has the protected ground, the particular social group. But was his membership in that group at least one central reason for the harm suffered and feared, as asylum law requires? It was, said the Fourth, or at least enough that a remand is needed. Especially as the Fourth Circuit has, quote, cautioned the BIA against taking an excessively narrow approach to the nexus requirement, especially in the context of family ties, end quote. What a quote for this case to use as appellate counsel. Not looking good for the BIA's underlying decision with these quotes used out the gate. Going to keep going, though, in a quote that will likely feature heavily in future similar appeals. Quote, an IJ commits legal error when the IJ centers his analysis on the reasons why the gang threatened and persecuted the petitioner's family, rather than on the reasons why the gang threatened the petitioner himself, end quote. Emphasis by the court. That's what the IJ apparently did here. It doesn't overly matter under Fourth Circuit precedent why the gang killed Mr. AG's brother or targeted the other ones. What matters is why they were targeting Mr. AG. With the issue properly framed, the Fourth Circuit, quote, failed to see how family membership necessarily was subordinate to these other motivations of monetary gain and gang recruitment, when the sole basis that Mr. AG presented for his fear of future persecution was that the gang would target him due to his relationships with his siblings, end quote. And of course, Mr. AG was deemed credible below. How do we know that family membership played a role? Well, for example, quote, when gang members tried to recruit the petitioner before he fled to the United States, they referred to his siblings in the U.S., demanding that his family members financially support the gang's activities. And notably, the gang members harassed the petitioner at the same family home that the gang marked later with the sign MS after Moises fled to the United States, end quote. If your case has similar facts, note them and note this decision. And that's just past persecution. Mr. AG also testified how MS-13 engages in, quote, revenge killings, end quote, against people like him, particularly due to Moises' recent refusal to smuggle drugs and then his flight out of El Salvador. The IJ and the BIA failed to analyze that sufficiently. The Fourth Circuit just doesn't seem to think that the BIA adequately analyzed the case, and that it disregarded testimony, which of course is evidence. An asylum seeker, quote, is entitled to know that the court deciding his claim reviewed all his evidence, understood it, and had a cogent, articulable basis for its determination that his evidence was insufficient, end quote. The Fourth Circuit here is in it to win it. No expert testimony either. But Mr. AG did credibly testify that, quote, the gang members threatened to kill all young male members in his family, end quote, and that MS-13, quote, always looks for someone in the family to kill, end quote. That's evidence. And heck, even Moises himself was granted withholding of removal by a different IJ in the United States. So it got remanded. The Fourth Circuit affirmed the denial of cat protection, though. To establish eligibility for cat, a non-citizen must establish, among other things, that the government would consent or acquiesce to the torture. Not seeking help from the police when threatened is often relied upon to deny cat protection, although that requirement is found nowhere in the regulations, that is, reporting it to police. And true in the Fourth Circuit, quote, an applicant can be excused from seeking government intervention if to do so would have been futile, end quote. And that's essentially what Mr. AG argued. But to the BIA, Mr. AG didn't really explain his reasons specifically or sufficiently enough. The Fourth Circuit saw no error in the BIA's rationale there. If you need good Fourth Circuit precedent on that issue, though, check out the en banc decision from Portillo-Flores v. Garland, episode 62. The Fourth Circuit continues to push the needle on asylum, which means congratulations Eric Raul Suarez for petitioner. A final thought. I still wonder how Mr. AG got around that one-year filing deadline. My guess? The arrival of Moises in the United States and, of course, Moises' refusal to smuggle drugs for MS-13 constituted materially changed circumstances that therefore made Mr. AG's late-filed asylum application timely. That's what I'd argue, at least. Always curious. And that is AG v. Garland. The conference potting concludes with Farnum v. Garland, published by the 10th Circuit on June 21st, 2023. This case is about frivolous asylum applications. Miss Farnum filed one in immigration court. She is from Zambia, quote, entered the United States in 2001 and filed an asylum application using a false identity and false asylum claim, end quote. She claimed to be a Tutsi from the Democratic Republic of Congo. She testified to it all falsely in immigration court, and she was found not credible. She actually got the case remanded after she appealed it to the BIA, and then she didn't show up for her remanded hearing, and so she was ordered removed in absentia. Not the best look for the immigration world, but also there will always be unfortunate apples. Miss Farnum was not physically removed, married a U.S. citizen, and applied to adjust to lawful permanent resident status under her real name in 2009. And she adjusted, but it all caught up with her when she applied to naturalize in 2013. It all hit the fan, what you may ask, I will not say, and she ended up back in removal proceedings. Which, to be honest with you, was a more favorable outcome because DHS might have been able to simply enforce that old removal order instead. Maybe not, because she was already an LPR, albeit under false pretenses. Which is precisely what DHS then alleged in her removal proceedings, that she obtained her LPR status through fraud. That allowed Ms. Farnum to apply for an INA Section 237A1H waiver, which can indeed waive the inadmissibility and removability of someone who obtained their LPR status through fraud. In the alternative, Ms. Farnum sought to readjust her status through her U.S. citizen spouse with a fraud waiver at INA Section 212I. A slightly more cumbersome avenue, which would additionally have required that Ms. Farnum establish that her U.S. citizen spouse will suffer extreme hardship in her absence. 237A1H has no such hardship requirement, which is why readjustment with a waiver is the alternative relief sought. The immigration judge, however, had other plans. The IJ held that Ms. Farnum filed a frivolous asylum application way back when, was advised of the consequences of doing so, and so she was barred from all relief under the Immigration Nationality Act, including what she was applying for. Which is the consequence of filing a frivolous asylum application. Don't do it. The BIA affirmed. Before the BIA and the 10th Circuit, Ms. Farnum conceded that prior application was frivolous, but made a unique argument. She argued that, quote, the immigration judge erred in making the frivolous finding and then invoking the statutory frivolous bar in the same proceeding, end quote. That is, Ms. Farnum reads the frivolous asylum penalty as only applying to future removal proceedings, or immigration applications, and not to the relief applications filed in the same removal proceeding as where the frivolous finding is made. The 10th Circuit did not agree. Had they, it would have kind of blown up the frivolous asylum bar. Statutory text is of course important. The frivolous asylum bar at INA Section 208D6, quote, provides that a non-citizen who knowingly submits a frivolous asylum application and receives appropriate notice shall be permanently ineligible for any benefits under this act, effective as of the date of a final determination on such application, end quote. A frivolous finding requires a finding that the applicant deliberately fabricated material elements of an asylum application, that the applicant had notice of the immigration consequences of doing so, and that the applicant, quote, had sufficient opportunity to account for any discrepancies or implausible aspects of the claim, end quote. All met here. But the statute that I just read, and definitely the regulations, additionally provide that there must be a, quote, final order by an immigration judge or the Board of Immigration Appeals specifically finding that the non-citizen knowingly filed a frivolous asylum application, end quote. Brilliant argument, really. By definition, there can be no final order of removal until an immigration judge rules, and if an appeal is taken, the BIA rules. So how, Ms. Farnum argues, can the frivolous asylum bar apply in the same proceedings that the frivolous finding is issued in? Because the finding isn't final at the time that it's being used to deny relief. Makes sense to me. Of course it would. In matter of XMC, BIA 2010, however, the BIA, quote, concluded a determination that a non-citizen had filed a frivolous application for asylum can be made in the absence of a final decision on the merits of the asylum claim, end quote. The BIA believed in that 2010 decision that, quote, in the context of Section 208D6, the phrase final determination on such application includes a final order determining that an asylum application is frivolous, end quote. Regulation be damned. Isn't that mostly our deference, though? If the BIA and XMC is really analyzing the regulatory finality requirement, and I'm not sure if it is, and if, of course, the BIA believed those regulations ambiguous, Supreme Court precedent tells us that the 10th Circuit doesn't owe XMC that much deference at all. Undiscussed here. Because the 10th Circuit kind of agrees with the framework outlined in matter of XMC. As the 10th Circuit reasoned, the IJ's frivolous asylum finding did eventually become final, when the BIA affirmed the IJ's finding. And in any event, even if Ms. Farnum is technically right, once the BIA then affirmed that frivolous finding, Ms. Farnum then again became permanently barred from all relief, forever. Strange procedural stuff. Probably why the BIA reasoned in matter of XMC that the IJ can make a frivolous finding and then implement it all in the same proceeding. The alternative reading, reasoned the 10th, would be chaotic. Quote, an immigration judge makes the required frivolous finding, a final order is entered, and the bar can only be enforced in some future hypothetical immigration proceeding. End quote. Once a frivolous asylum finding is made by an immigration judge, quote, nothing requires the IJ to consider other claims that are barred as a result of the frivolous finding. End quote. Even though, to be honest, it seems like the 10th Circuit and even DHS, when it later tried to amend the regulations under the Trump administration, agreed that yes, the regulation is pretty clear that the frivolous asylum bar only applies once that finding becomes final. Which again, when an appeal is taken, only happens when the BIA issues its final decision affirming the IJ. Very smart arguments made by very smart counsel, but ultimately rejected. And that is Farnum v. Garland. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate for 5 credit hours, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all. And follow the show on Instagram and Facebook at Immigration Review, and send us a tweet at ImReview. That's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.